rise. The Court of Appeals Division 1 is now in session.
You may be seated. Thank you. We're here on our case number 1CACV150643, McGovern versus the Arizona Healthcare Cost Containment System Administration. Counsel, as you know, each side's allotted 20 minutes for your argument. The appellant may reserve any amount of time you would like to use in rebuttal, but if you do decide to reserve time, you're in charge of keeping track of it for yourself. The clock on the podium will reflect the total amount you have remaining, including what you may have decided to reserve. We have, let me say, we record these proceedings, so when you approach the podium, and for the appellant each time, if you would do us the favor, please, of reciting your name and the name of your client into the microphone, we'd be grateful for that. Would one of the law clerks please go back and close the two inner doors? Thank you. We have reviewed the briefs in the case, and we've reviewed the record. We've also discussed the case in our conference this morning. So with that, Mr. Johnson, you may proceed.
Thank you, Your Honor. Logan Johnston for the Director of Access, Thomas Betlak. I will try to reserve maybe 5 minutes for rebuttal. Obviously, Your Honors, I am appealing here. I'm the appellant. I am asking you to reverse the Superior Court. In this case, Judge McLennan did not explain why he chose to reverse the director. He did not explain his reasoning or rationale, so I will go directly to why we believe that the director was correct, why his determination that Mr. McGovern in this case was not eligible for access benefits was a correct application of the law and was supported by substantial evidence in the record. The context, of course, is Medicaid eligibility. As this court and others have repeatedly recognized, as one court put it, quote, the Medicaid program would be at fiscal risk if individuals were permitted to preserve resources for their heirs while receiving Medicaid benefits from the state, unquote. Medicaid funding is limited, and Congress has set very low thresholds for eligibility for the program. A person may have $2,000 in assets and no more than $2,100 in monthly income when he or she applies in order to be eligible.
Let me ask you about the income issue first. It seems from the record that Mr. McGovern had income over the threshold during the month that he applied simply because of a transfer out of his trust account, closure of his trust account. But Access is not contending that we should reverse on that ground because he wouldn't have that income next month, the month after.
No, Your Honor. The facts are, I think, that the income would have transferred to the income-only trust effective in November. So the analysis Access did was for the month of October in which he applied, and for that month he was over on income as well as assets. So it's a little bit confused in the record. I maintain that both issues disqualified him and that Mr. McGovern chose only to contest the resource issue, at least for the month of October when he applied. So that's really the only issue that was addressed by the ALJ. It's the only one that's addressed by the director, and I think it's the only one that's really here on appeal.
Thank you.
The facts that were stipulated, Your Honors, are that in October 2013, Mr. McGovern applied and he disclosed his income and his assets, and his income was a little over $3,000 in Social Security benefits and a pension fund for that month. He also had a car that had a net value of $4,500. He had a bank account with something under $2,000 in it, and he had two bank accounts with his daughter, which we have no idea how much money was in either account, even to this day. Prior to his application, he was being assisted by his sister, who had a power of attorney because he was disabled, and she was able to revoke the McGovern Family Trust. She created the income-only trust that I mentioned a moment ago. She rerouted his Social Security income to that trust effective November. She closed one bank account and opened another. Then she tried to get Mr. McGovern's daughter to let her do something with Mr. McGovern's car and the two bank accounts that the daughter owned jointly with the father. Mr. McGovern asked Access to create a conservatorship. Access said that's not what we do. Mr. McGovern's sister went back to the bank and the trust, the pension fund rather, and tried to persuade them to give her access to those funds even without the daughter's consent. When that did not work, she did not create a conservatorship. So the end result was that Access denied Mr. McGovern's application for eligibility for both reasons. He was over income, he was over assets. He passed away in 2014. The nursing home now argues that the assets that the daughter would not cooperate on, the pension fund, the joint bank accounts, and the Ford Focus, should all be considered unavailable assets, unavailable resources that should not be counted towards the eligibility determination. We, of course, respectfully disagree. The federal rules, the federal policy from the Social Security Administration that governs the interpretation of Medicaid eligibility, and the Access policies all say the same thing in almost identical language. The test of an available resource is whether the person, quote, has the right, authority, or power to liquidate the property or his share of the property, unquote. The Social Security Administration manual adds that a resource is available if the person, quote, is not legally restricted from using the asset for his or her support and maintenance, unquote. And for an asset to be unavailable for access purposes, one of three things has to be the case. First, the person, quote unquote, does not have the legal right, authority, or power to liquidate the resource. Second, the person, quote, does not have the legal right to spend or convert the resource for his support and maintenance, unquote. Or three, quote, there is a legal bar to the sale of the property, e.g., if a non-responsible relative co-owner legally blocks sale of jointly owned property, unquote.
That's, the latter is under the Palms?
The latter is the Access Policy 703.01 B and C, Your Honor.
Okay. How do we draw the line between the partition cases, the cases that say you don't, that's too far, that's too much to require an applicant to go to court to get a partition order, versus you need to go to court to get a conservatorship?
Well, I think the Palms, Your Honor, that you just referred to, the Social Security manual, makes a distinction, and a clear distinction. I think we quoted at page 9 of our reply brief, and it sets forth three circumstances under which a third person may be involved in the determination of whether or not an asset is available. They go through the three. One is access to the resource via an agent. That could apply here in terms of the sister with the power of attorney. The second possibility is access only via litigation. When there is a legal bar to the sale of property, then litigation would be required to get access to that asset, and the POM says you don't have to do that. The third alternative is, quote, access via petition conservatorship accounts. And it makes the clear distinction between those three types. Conservatorship is definitely dealt with separately, and the POM says that if you have to petition to a conservator to get an asset released or liquidated, that's okay. That does not make the asset unavailable. It's quite clear on that. The access policies are similar in their scope and in their application.
Counsel, doesn't that seem a bit arbitrary to say conservatorship, yes, partition action, no, but on what basis? I mean, you know, so you could have somebody sitting on $1 million piece of property, could be tied up with 5 siblings, so to speak, and if it's too hard to get to, so then those resources are unavailable. That resource is unavailable because it's tied up in real property, and yet you could have the situation we have here where a conservatorship would have to be filed. It obviously involves at least some legal expenses, but who's to make the judgment that a partition action is that much more expensive than a conservatorship? I mean, you go into court, you say, my siblings won't agree, let's put this thing up for sale. And the court orders the property to be sold. Now, timing might take a little bit longer. I agree with you on that, but it seems pretty arbitrary to me that the court, and I'm not saying that the regulations seem to say this, but go back to the original language of the CFR that says right, power, authority, right? Right, power, authority to control the asset. I don't see any difference between real property and bank accounts.
Your Honor, the rule makes the distinction of there being a legal bar that has to be overcome in the litigation context. In the conservatorship context, the assumption is that this is your own property, you just need somebody to exercise your right to get it. In the litigation context, in the partition of real property, that's something that's dealt with separately at the federal level and at the state level because of the complexity and because there is the legal bar. If there's no legal bar, then the conservatorship analysis would apply to both instances. So it is a question perhaps of convenience to some minimal degree, but it's more the legal bar and whether there is something like a divorce that has to be instituted or a lawsuit to get a brother who's got a legally binding agreement to that permits him to bar the sale. If you have to overcome that kind of thing, that's the litigation example that the federal and state rules say you don't have to go to. And in the cases that Mr. McGovern cites that apply that analysis, you see consistently it only applies fairly rarely and only when there is a tiny value to the asset that has to be recovered, or one that may not be quite so tiny but will be overshadowed by the expense of the litigation.
So one way to look at it might be that the litigation exception applies when there is a legal dispute about the power of the party to liquidate the asset.
Correct.
Here, or in the conservatorship context, there's no dispute about whether the party has the power to liquidate. It's his competence to do so, which is a different issue entirely. He's not disputing it with someone.
That's correct.
It's not a legal contest about his legal right to do it.
In this case, the argument by Mr. McGovern is that it was inconvenient. It was difficult for the sister to get anyone's cooperation and affect the liquidation of these assets. That's not the test. If it were, Your Honors, I submit Medicaid eligibility would be a meaningless exercise to some extent because all you'd have to do is put your asset into joint ownership with someone and have that person refuse to cooperate in liquidating it. The person would get to keep the asset, you'd get your Medicaid eligibility, and the public would wind up paying for people that Congress did not intend to cover. And the end result of that, Your Honors, would be that those already low thresholds of $2,000 and $2,100 that I mentioned before would have to go down because you'd be taking care of all the people who would take advantage of this particular device to shield their assets in exactly the way that is not intended to be allowed by this program. And they'd get into this program and add to the expense of the Medicaid program. The thresholds would have to go down, and the only people the people that would be hurt the most are those who don't have assets of this type or size to shelter in this way. They'd be kicked out of the program because they're just over that new threshold. That is not the way the program was intended to work. It's not fair. It makes no public policy sense. And there's no case that says outside of this rare exception for litigation in the divorce and partition situations, that kind of analysis even is suggested. If you own an asset and there's no dispute about the ownership, you're supposed to liquidate it. And the case here is about Mr. McGovern failing to meet his burden of proof to show that he could not liquidate these assets. He even suggested to Access, as I mentioned before, that a conservatorship was the way to go, but he chose not to institute one. There is no showing that he couldn't afford one. I mean, he spent much more money on this case than it would have cost to get a conservatorship. There's no evidence of how much that would have cost. There's no evidence really of how much he had in assets because we don't know about those 2 bank accounts. So he failed in his burden of proof to show that these assets could not be liquidated, and because he did, Your Honors, I submit that the director correctly decided this case. The other thing I would add is that I think his reliance on the Smith case decided by this court a few years back is completely misplaced. You cannot equate a man with money in the bank and a car in the driveway to the Smiths in that case, who merely had a right at some later time to insurance proceeds that had not been quantified, had not been paid, hadn't even been promised at the time they wanted to count them. To the contrary, I think the court's reasoning in Smith applies here. There the court said, the determining factor is the existence of the legal right to liquidate or control. Thus, whether plaintiff had the authority to liquidate as of the assessment date is dispositive. And I'll reserve the rest of my time, if I may, Your Honors.
Thank you.
Morning, Your Honors. Tyler White on behalf of Patrick McGovern. If it may please the court, this case really doesn't have to be as confusing as counsel makes it out to be. It's a pretty simple case with a pretty straightforward issue. I mean, should an incapacitated person who has spent all the funds to which he has access then be denied his right to Medicaid coverage based on these assets, almost fictitious assets that he couldn't access? And the answer, of course, is no. No from an intuitive, gut, human level, and no from a legal standpoint, because all of the authorities require that both ownership and accessibility are present for an asset to be available. And in this case, Mr. McGovern undoubtedly owned the assets, but he did not have access to the assets. And without access to these assets, they're really just assets in name only, liabilities, because they prevented him from qualifying for all tax. And so counsel makes several arguments that are worth addressing right up front. And I think the most important argument is that he argues that that Mr. McGovern somehow had this legal right, and this right equates with his accessibility element of the available asset. And I would submit that Mr. McGovern exercised all of the legal rights that he possibly could. He had the foresight to execute a power of attorney when he had capacity. Then he lost capacity, and his sister took that power of attorney to the bank and to the pension fund, and they refused to honor it through no fault of Mr. McGovern. And she didn't just give up. She made multiple attempts. She hired an attorney to help her with this, and the pension fund and the bank held strong. And counsel has argued that this is just a business obstacle, but it's not a business obstacle. It's entirely based on Arizona state law, and it's ARS 14-6205, and this outlines the situations in which an agent may access a jointly owned account, and it specifically requires a writing signed by all parties. All parties in this case include Mr. McGovern and his daughter. And his daughter, she refused to cooperate. We stipulated to that fact, and that's the whole point of stipulating to a fact. We say that you can't stipulate to a fact and then argue the veracity of the fact. We've already agreed to that she wouldn't cooperate. Counsel then argues that Mr. McGovern should have gone further, and that perhaps he should have pursued a conservatorship. He had this right to pursue conservatorship. But I would say that if anybody didn't have the right It was Mr. McGovern. I mean, he's the incapacitated person. He can't exercise that right. And so the question is, who's supposed to exercise that right for him? And I think the counsel is arguing that the agent should have done so. And maybe the agent, under the power of attorney, could have exercised his rights, but she's not required to go into her own funds. Access doesn't require people to spend their own money to pursue conservatorship. We also stipulated to the fact that at the outset, Mr. McGovern was under $2,000 in the accounts to which he had access. And no, there's no evidence in the record of how much a conservatorship proceeding would have cost, but I think we all know it would have been more than the $1,000 that Mr. McGovern had.
I guess I'm not sure of that.
Okay, well, all right. Okay, fair enough. So the other point with conservatorships I'd like to make is that saying that the right to pursue conservatorship equates with the right to a favorable outcome in a conservatorship proceeding. It amounts to saying that your right to file an Altex application equates with your right to qualify for Altex. It just doesn't. There's a process that has to be consummated before that right is perfected. The right doesn't come into existence until the judge signs the order and issues the papers, and at that point in time, that right is consummated. But again, somebody else had to exercise that right, and nobody's required to spend their own money on a conservatorship. Am I supposed to do it pro bono? There's no authority for that. The nursing home, I mean, they're the good guys here. They're the ones who have been providing care month after month to a man in a vegetative state at virtually no cost. Are they required to pay for a conservatorship proceeding? And we have every reason to believe, well, the only evidence we have in the record about the daughter is that she wouldn't cooperate with the Altex proceeding. She wouldn't give up possession of the vehicle. She wouldn't sign the joint acknowledgement form. So what's to lead us to believe that she'd cooperate in a conservatorship proceeding? Notice has to be given to all interested parties, and the interested party in this case is the daughter gone rogue who wouldn't even help her dad get free health care. And I'd also like to point out that counsel relies on this section of the Palms. And he says that it requires people to get conservatorships, but it doesn't. It deals with conservatorships that are already in place. This section of the Palms deals with existing conservatorship accounts. And Mr. McGovern did not have a conservatorship, much less a conservatorship account. And he also argues that it would have been cheaper for Mr. McGovern to pursue conservatorship. Well, we didn't foresee that we needed it. There was a very limited amount of funds, and our perspective is that the asset was inaccessible and unavailable. This isn't a test case. This is a real case about a real person who needed care and a facility who is spending money basically month after month with the anticipation of being reimbursed. We didn't foresee the need of a conservatorship. We had powers of attorney in place. We didn't believe we needed the conservatorship. And the flip side of that argument is that it would have been cheaper for Access to pursue conservatorship than to go through all these appeals. They have resources. They have an attorney right here who could have pursued conservatorship, and that would have been cheaper than pursuing all these appeals. The only attorney who's been paid so far is Mr. Johnston in this case.
Does the record contain any information as to the dollar amount in the Bank of America accounts?
We have no access to it. They refuse to give us bank statements.
So the answer is no.
Right.
So who has the burden in this case? I'm just wondering I suppose Access wants us to assume that there's an amount, that those accounts contain an amount that's in excess of the resource cap.
Precisely. They want us to assume that.
It's who has the burden of showing that the applicant doesn't have that? I suppose that's on the applicant, right?
Well, yeah, it would be on the applicant, and it is on the applicant, but in this particular case, the asset is inaccessible. That's the whole issue.
That's your point. Is there a case anywhere that across the country that relies on these regs and the policy manual to say that an applicant doesn't have to bear the burden
There
of
is.
pursuing a conservatorship?
There is. In fact, there was a case out of the District Court of Oregon just last year by the name of Winston v. Colvin. And I really like what they said in this case. They said that the analysis of what constitutes a resource cannot be evaluated detached from reality. And in this Winston case, there was a mentally unstable third party who who prevented the sale of the asset, blocked access to the asset. The only way to access the asset would have been through court involvement, and the applicant did not have the funds to pursue court involvement. And the court analyzed this through the context of reality, and they determined that asset was inaccessible, unavailable.
Conservatorship case?
It was a land partition case.
Okay, so that's a partition case. Is there a conservatorship case?
Well, I would argue that litigation includes conservatorship. The next case I want to discuss is Cubetin v. Estrue, and this is out of the District Court of Massachusetts in 2009. And in this case, the court specifically said that the text of the POMS instructions makes no distinction between types of litigations, and the court declines to read that limitation into an otherwise clear policy statement. It's not for Mr. Johnston or for me to say that conservatorships aren't litigation, and the POMS don't clearly distinguish between that. The POMS only talk about existing conservatorships and then litigation, and the idea, I think, is that if there's a conservatorship already in place, then yeah, petition the court. That's all it takes. But if the conservatorship is not in place, who knows how it's going to turn out? Who knows whether it's going to be contested or not? There's a process that has to be consummated before that conservatorship can happen. And counsel also, there are a couple other points I'd like to talk about. The Smith case. In the Smith case, I mean, the published opinion is consistent with the idea that both ownership and accessibility need to be present. And of course, in that case, the community spouse tried to include an inaccessible asset in the resource allowance in an effort to allow her to keep more money in the spend down month. And this court rightly decided that the inaccessible asset was unavailable. So just to put this in context, in the Smith case, Access argues, because it suited their position, that an inaccessible asset was unavailable. And now in this case, speaking out of the other side of their mouth, they say the inaccessible asset is available. They're just tailoring the argument to suit the position that they want. And this court already made up its mind. It made up its mind. And it said specifically the key determination is whether an applicant has immediate access to the asset for personal medical use before seeking governmental assistance. And he did not have immediate access in this case. And immediate access, by the way, implies that convenience is at least part of the analysis. And then the court goes on to give...
Counsel, where do you think that where the court, our colleagues back then came up with the word immediate? I mean, is there other case law, or is there origin for that in the statute? Because I haven't seen that anywhere else in the regs or the statutory language to say immediate access.
I think maybe what they were getting at is the difference between a liquid asset and an illiquid asset. So a liquid asset can be, you can have immediate access to it, and an illiquid asset is one that will take a period of time to sell. But
yeah, or is the explanation, could the explanation be the court was trying to emphasize the fact that on the date of the accident, the actual date of the accident, they couldn't just get those funds from the insurance company. They weren't available. I mean, they weren't.
It could be, and that's analogous to the case at hand. On the date of the application, he could not access the funds. There were no funds available to pursue the conservatorship, and it's essentially the same thing. He didn't have access, and I think that the immediate word is interesting, but the access word is more important. They're talking about accessibility, and they give three factors to inform this key determination of accessibility. And the first of which is whether other funds readily available to that person for support and maintenance have been used for those purposes before the state provides financial support. And that's the case here. We submitted the bank statements, and the bank statements indicate that the money went to the care home each month, and when he was just about out of money, he filed filed for Altex. There was no gifting. There was nothing of that nature. It was he spent down organically and then filed for Altex. The second factor is whether the asset was available to convert to cash for use as support and maintenance. And that's not the case here. After multiple attempts, the pension fund and the bank manager said, no, you cannot access these assets, and that's in the record. And the third factor is whether the asset was actually available and not only in the form of an unliquidated cause of action. And if anything, this asset closely parallels an unliquidated cause of action because there's a long court process that stood between Mr. McGovern and the asset. And it was a speculative process. I mean, at most, it was a prospective, potential, possible right. It wasn't an absolute right. So counting the assets in question is, in my opinion, inconsistent with the Smith decision. And in the briefing, counsel distinguishes this case from Smith.
Let me back up, if I could.
Sure.
Just, I was thinking over your prior comment about the outcome of the conservatorship would be speculative. Well, but if the court denied the conservatorship, wouldn't the necessary conclusion, the basis for the court's denial, have to be that Mr. McGovern was competent? And in that case, he could have transferred the funds.
Right. Yeah, and I say that the process is speculative because we don't know whether the sister would just sign off on it or whether she would contest it. We don't know how long it would take, and then we don't know what was in the accounts. It could have been a penny. It could have been $1 million. Nobody knows because we were not given access to it. And you can come to your own conclusion about what was in the account at the end of the day. There's nothing in the record to show.
Well, so the outcome, it seems to me the outcome of a conservatorship proceeding is pretty well certain. The accounts would have been accessed because either the court would have found him competent and he would have done it, or the court would have found him not competent, and then a conservatorship. Conservative would have been appointed. The conservative would have accessed it.
Sure.
What's uncertain is the amount and the.
That's uncertain, and also it comes back to the issue of who's right, who has to spend this money, and Altex doesn't go that far. They don't require third parties to pay to get somebody on the program. They're only looking at the applicant, and the applicant had no access to the account. He had an agent, fortunately, but that wasn't good enough, and it wasn't his fault. That was just a situation he found himself in. And you know, there are that happens often. I mean, it could happen to any of us. People wind up in nursing homes and they have nobody to help them, and no way to access accounts, and nursing homes just end up spending money paying for these people because they can't get on the program. And in this case, counsel is arguing that there's this prospect of gamesmanship, that there's this idea that the ruling in Mr. McGovern's favor would open the floodgates to a host of fraudsters, which would then cause the limits to drop and kick poor people off of the program and be contrary to what Congress intended. But it's impossible. That's impossible for two reasons. First of all, with real property, if you add a joint owner to that piece of real property, Altex penalizes you by a period of non-coverage. So there's already a built-in preventative mechanism for real property. And then with bank accounts, if you have the capacity to add somebody to your bank account, then you also have the capacity to access the bank account yourself. And so you have access and ownership, and the asset is available.
Except in this case.
Except in this case,
time marches on and
time marches on, right? But if people want to game the system that way, all they have to do is give their money away and wait 5 years, because Altex only looks back 5 years. There's already ways to do things like that, and this isn't going to open the floodgates to a bunch of fraudsters.
well, here didn't the arrangement of the account, didn't the daughter's refusal to assist, didn't that mean that the monthly pension checks weren't accessible?
That's correct. The pension, we funded a Miller Trust with the Social Security. The pension checks were deposited into that account, and if you just connect the dots, the daughter is absconding with the money. That's why she's not cooperating. And I don't believe that an incapacitated person should be punished for that. In terms of accessibility, Mr. McGovern just had no way of getting into that account. And the daughter just wouldn't cooperate. We're talking about cases, and in the briefing, counsel relies on this Chambers case pretty heavily to show that it's this legal right that matters the most. And in the Chambers case, they counted jointly owned property as an available resource, and the rationale that they gave was that they couldn't find support in the regs to exclude jointly held property, and they just got it wrong. CFR 416.1240A1 specifically allows for conditional exclusion of jointly owned property, and this is because the rules aren't designed to keep people off of the program, right? They're designed to help people, and this goes back to the standard of review that was laid down by the Ninth Circuit in the Benitez case. And they said that the Social Security Act is remedial in nature, and it's designed to provide support. Designed to provide support to people like Mr. McGovern, who have exhausted all their resources on their care, and then have this fictitious bank account with a hypothetical value assigned to it that we say is over $2,000, and that he can't get off the program. So, from my perspective, if anybody's exercising or engaging in gamesmanship, it's access, because this isn't about the future of Medicaid. This is about a real person who really needed coverage and who was denied that coverage based on these fictitious accounts. So the Superior Court got it right, as did this court in Smith. Mr. McGovern lacked assets to the assets in question, and therefore they were unavailable. And that's it. I mean, it's really that simple. And with that simplicity comes the logical conclusion that Mr. McGovern should have been eligible beginning with November of 2013. And by the way, to address your question, Judge Johnson, to Mr. Johnston, applications are open for a 3-month window. That's standard procedure. And so that money coming out of the trust in the first month, that put him over for October, but that doesn't close the application. Applications stay open for 3 months, and this would have been a case in which he had second-month eligibility.
Okay.
So unless there are any questions for me, that will be it.
Thank you.
Thank you.
May it please the court again, Logan Johnston for Director Betlach. Let me respond to a couple of things that Mr. White said. First, I don't think he can really argue here today or in his briefs that they did not foresee the need for a conservatorship. They suggested that Access create one, and then they decided to drop the idea when Access wouldn't do it for them. They can't argue about this last idea.
Counsel, on that point, what about counsel's question? Who is supposed to file the conservatorship, and how far does an agent holding a power of attorney, how far does that agent obligated to go on this?
Yeah, I'm not sure I understood Mr. White's argument that we're expecting third parties to pay for this thing. We're not. The conservatorship costs would come out of Mr. McGovern's assets here.
Assuming there's money.
Assuming there's money, correct. And if there weren't money to pay for a conservatorship, that is something he could have tried to prove at the hearing and might have had some bearing on things. But there's no evidence that he couldn't. There was no attempt to prove that.
What about his point that the POMs only deal with existing conservatorships and do not specifically say anything about going out and creating a conservatorship or obtaining a conservatorship?
In the same way, Your Honor, they don't talk about the difference between existing litigation and creating litigation. The distinction is the legal bar, the distinction being that if there's a legal bar that you have to overcome, then it's a litigation situation. If there's not, and there was no proof of one here, it's a conservatorship situation, and the distinction is quite clear in the POMs. that conservatorships do not make an asset unavailable, whereas litigation might. But again, it's not a question of our expecting either the nursing home or the sister to fund the expense of getting a conservator. Frankly, there's nothing in the record as to who funded any part of this case. We just know that a lot was spent. He made the argument towards the end of his argument about there being a conditional exclusion possibility here. That is not anything that has any relevance here. Mr. McGovern never asked for a conditional exclusion. I don't think it would apply even if he had, but that's not part of the case. He talked about the Winston case. That's a partition case where there was a legal bar to the person applying for benefits getting his or her interest in that particular piece of real property. He mentioned the Coupeton case and said that that case shows that the Palms makes no distinction between types of litigation, implying that maybe conservatorships fall within that umbrella. Well, they don't. We've discussed that in some detail, but what that case says is the litigation exception in the Palms goes to both divorce proceedings and partition proceedings. It doesn't say one word about conservatorships and doesn't imply anything of the sort either. He wound up saying that Mr. McGovern absolutely could not access his own assets. Well, that's simply not been proved. All we have in the record is that attempts were made, they didn't go far enough, and nothing took away his legal right to his own assets. There is no dispute he owned these assets. There is nothing that was ever established that showed he couldn't spend them for his support and maintenance. There was nothing to show that he couldn't liquidate these. There's nothing to show that there was a legal bar to his access to them. The cases we've cited do not make a distinction between incapacitated or disabled persons and persons who don't have such disabilities. The same rules apply to everybody. So I would just simply say he had the burden in this case to prove that he could not, as he maintains, could not liquidate these assets, could not use them for his support and maintenance, had a legal bar of some sort that precluded him from access to these assets. He didn't do that. The director's decision was correct, and the Superior Court decision should be reversed. Thank you, Your Honors.
Thank you to both of you. We're grateful for your briefing and for your argument. We'll take the matter under advisement and issue a decision in due course. Now we stand adjourned.